Day 30 Trump Manhattan Civil Fraud Trial. Trump's legal drama is filled with moments of levity. Donald Trump's 30-day civil fraud trial in New York, spearheaded by AG Letitia James, alleges a decade-long scheme by Trump, his sons, and other execs. The trial unveils new twists each day, holding significant implications for Trump's fortune and real estate empire. Has Michael Cohen's testimony caused the trial to collapse? In another instance far from the courtroom, former President Trump has claimed that the civil fraud case brought against him by Letitia James has imploded due to the testimony of his former fixer and personal attorney, Michael Cohen. Trump, in a post on Truth Social, labeled the case as rigged and made unsubstantiated allegations of fraud against Judge Arthur Engoron and James. Trump pointed to Cohen's admission of lying on the stand and asserted that he never instructed Cohen or anyone else to inflate financial numbers. Despite Cohen's explanation that Trump speaks in a manner akin to a mob boss, Trump insists that the case's purported implosion results from his former attorney's testimony, challenging the credibility of James's case. Moments of levity. One of the day's highlights was the return of Donald Trump Jr. to the witness stand. As the eldest son of the former president, he faced questions related to the alleged fraudulent activities. Meanwhile, a moment of levity unfolded during a break, with Trump attorney Chris Kise making a jest about coaching from the sidelines, drawing parallels to notable football coaches. During the trial, Judge Engoron asked Flemons about his compensation for serving as an expert witness. Flemons mentioned that he couldn't estimate the total amount but stated that his hourly rate was $925. Similarly, McKeel McCarty, another expert witness for the state, testified earlier this month that he charged a similar rate. The GSA determined that Trump's statements were not in compliance. The courtroom drama continued with expert witness Stephen Collins shedding light on the General Services Administration's GSA review of Donald Trump's proposal to renovate the old post office in Washington, D.C. Collins revealed that the GSA had identified issues in Trump's statement of financial condition, qualifying it as not complying with Generally Accepted Accounting Principles, GAAP. However, the GSA considered Trump's financial capability as only a fraction of the evaluation factors. The legal proceedings took an unexpected turn with a state attorney's suggestion that Trump may be attempting to throw accountants under the bus. The remark came during the redirect examination of the defense's expert witness, Jason Flemons, and led to objections from Trump's lawyers. Valuing properties is not an exact science. Later in the day, the defense's accounting expert, Jason Flemons, took the stand. He emphasized that valuing properties is not an exact science, supporting the defense's argument that the valuation process is subjective. Flemons stated that determining estimated values could yield a range of values, emphasizing the lack of a single correct answer. This perspective aligns with the defense's contention that the alleged fraudulent valuations were a result of Trump's business acumen. The New York AG requests an extension of the deadline to respond to Trump's attorneys. New York Attorney General Letitia James has formally requested an extension until December 8 to respond to the motion for a mistrial filed by Donald Trump. The motion, submitted a day earlier by the former president, alleged bias on the part of Judge Arthur Engoron and his clerk. If the extension is granted, the decision on the mistrial motion would be postponed, likely extending any potential appeal until after the trial concludes. State Attorney Kevin Wallace justified the request, citing the trial's considerable daily attention and the approaching Thanksgiving holiday as factors contributing to the need for an extended deadline. Wallace emphasized the Office of the Attorney General's commitment to a thorough response, underscoring the perceived lack of merit in Trump's application for a mistrial. A New York appeals court judge, David Friedman, paused a gag order. In a significant development in Donald Trump's civil fraud trial, a New York appeals court judge, David Friedman, has temporarily lifted the gag order that prevented Trump from commenting on court staffers. The trial judge, Arthur Engoron, had imposed the gag order last month after Trump posted a disparaging social media remark about a court clerk, leading to a $15,000 fine. Judge Friedman, citing constitutional concerns over restricting Trump's free speech, issued a stay on the gag order during the ongoing appeals process. Trump's legal team, in response, filed a lawsuit against Judge Engoron, asserting that the gag order constituted an abuse of power. An emergency hearing was scheduled to address this matter, reflecting the complexities and constitutional implications surrounding free speech in the context of the trial. The legal maneuvering surrounding the mistrial motion adds a layer of complexity to an already high-profile civil fraud trial. The extension request signals the importance of providing the court with a comprehensive response, aiming to address and counter what the Attorney General's office views as baseless allegations in Trump's mistrial motion. As the trial unfolds, the strategic decisions made by both parties continue to shape the narrative and timeline of this closely watched legal battle. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.